This is 1A. I'm Joshua Johnson. Thanks for checking us out today. Last night, President Trump announced his choice to join the U.S. Supreme Court, Colorado Federal Appeals Court Judge Neil Gorsuch.
Standing here in a house of history and acutely aware of my own imperfections, I pledge that if I am confirmed, I will do all my powers permit to be a faithful servant of the Constitution and laws of this great country.
The seat Mr. Gorsuch might fill has been vacant since Justice Antonin Scalia died last year. Republican lawmakers refused to even consider President Obama's nominee, Judge Merrick Garland. Some Democrats say the seat is not Trump's to fill. In this hour, we'll learn more about Judge Gorsuch, consider what his confirmation might entail, and look at the Supreme Court today, including some of the cases on its docket now. Joining us to discuss this is Elizabeth Wydra. She is the president of the Constitutional Accountability Center, a public interest law firm and think tank. She joins me here in studio. Elizabeth Wydra, welcome to 1A.
It's so great to be with you.
Also with us is Kenneth Jost, the author of the Supreme Court Yearbook, published by CQ, and he writes the blog Jost on Justice. Kenneth Jost, welcome.
Glad to be with you.
Also with us is Josh Blackman. He's an associate professor at the South Texas College of Law and an adjunct scholar with the Cato Institute. He's the author of Unraveled, Obamacare, Religious Liberty, and Executive Power. Josh Blackman, welcome.
Thank you for having me.
There's a whole lot to discuss here, and we'd like to answer as many of your questions as possible, so email us, 1a@wamu.org, comment on our Facebook page, or tweet us at 1A. Kenneth Jost, let me start with you. Who is Neil Gorsuch?
Neil Gorsuch is a solid conservative judge with 10 years experience on the Federal Appeals Court in Denver, where he has a good reputation as a writer, as a collegial judge, well liked by his colleagues on the Federal Appeals Court there. He has a conservative record on, among other issues, religious liberty, two cases bearing on the contraception coverage under Obamacare. And at 49, he is relatively young. He will be if confirmed, he would be the youngest to join the court since Thomas joined the court at age 43 or Byron White joined the court at 44.
Let's get a little more of his bio. Where is Neil Gorsuch from? Where did he grow up? Where did he go to college?
Well, he's got silver-plated academic credentials. He is a fourth-generation Coloradan, but he came of age here in Washington, D.C. as the son of Ronald Reagan's combative administrator of the Environmental Protection Agency, Ann Gorsuch, now Ann Gorsuch Burford, after remarriage, and from here, well, he went to Georgetown Prep School here, and then to Columbia University for undergraduate, Harvard Law School, and then to Oxford on a prestigious Marshall Scholarship. That is a resume to die for. It's not quite as good as Merrick Garland's, not quite as good as John Roberts, but it's very good.
Yeah, if Oxford's the best you can do, it's not too bad. He also clerked for a number of justices. Is that right? He
clerked for Byron White, the Colorado connection there, Byron White from Colorado, and he got that clerkship as Byron White was about to retire. So he clerked for retired Justice Byron White, but White, in line with common practice, shared his clerk with an active justice, specifically Anthony Kennedy. If confirmed, that would make Gorsuch the first ex-law clerk ever to serve with, his justice.
With one of his future colleagues. Let's talk a little bit more about Judge Gorsuch's philosophy of the law. As we said in the intro, and as a lot of people have reported, Antonin Scalia is something of, I don't want to say a patron saint, but certainly a role model for Neil Gorsuch. Here's part of what he said in his speech last night at the White House after President Trump announced his nomination.
The towering judges that have served in this particular seat of the Supreme Court, including Antonin Scalia and Robert Jackson, are much in my mind at this moment. Justice Scalia was a lion of the law. Agree or disagree with him, all of his colleagues on the bench cherish his wisdom and his humor. And like them, I miss him.
Kenneth Jost, how are Neil Gorsuch and Antonin Scalia similar, and in what areas might they differ in terms of their jurisprudence?
They are similar Judge Gorsuch would base constitutional rulings on constitutional text and original meaning. The notion of a living constitution probably a little bit foreign to him. Statutory interpretation, plain text, whatever the law says. Don't go engage in examination of legislative history, and he preaches judicial restraint. How that plays out on some conservative issues, for instance, campaign finance. We don't have a record of Judge Gorsuch on campaign finance, but that's an area where conservative justices discard judicial restraint in favor of what they regard First Amendment rights of political speech.
So basically, he wants to view the Constitution as the framers viewed it, and not necessarily as we might view it in a more contemporary sense.
Exactly right. He did not rule on same-sex marriage when that issue was in front of the Federal Appeals Court, the 10th Circuit. But he has written about the importance of leaving political decisions for legislators, not judges, in a way that sounds very much like Chief Justice Roberts' dissent in the same-sex marriage case.
And in terms of judicial restraint, for those who are maybe not familiar with that term, you're talking about this idea that laws are made by lawmakers and not by the courts, and the court's job is just to interpret the law and not to push it in one direction or another.
Yes, and he said that last night. A judge's job is to apply the law as he finds it without regard to his political beliefs.
We're speaking about the nomination of Judge Neil Gorsuch for the Supreme Court and about the future of the court with Kenneth Jost, the author of the Supreme Court Yearbook and the blog Jost on Justice. We're also joined by Elizabeth Wydra of the Constitutional Accountability Center, Josh Blackman, an associate professor at South Texas College of the Law and a scholar at the Cato Institute, and with you. I'd love to hear your take on this. What are your questions about this nominee, about the Supreme Court, what's going on at the court these days, what are some of the big cases that are coming before the court, possibly how Judge Gorsuch might affect those cases if he ascended from judge to justice, and also about the confirmation process. What are you expecting? What do you think some of the questions are that should be raised? What do you make of all of this? Email us, 1a@wamu.org, comment on our Facebook page, or tweet us at 1a. Elizabeth Wydra and Josh Blackman, I'd like to hear from each of you what your initial reactions were when you heard that Neil Gorsuch was the nominee. Elizabeth, let me start with you.
Yeah, thank you. So I didn't think it was that big of a surprise. Obviously, his name was in the news, and, he's deeply beloved by conservatives, and, he's viewed to be a rock-ribbed conservative. He appears to meet the litmus test that Donald Trump put forth, which I find very disturbing, which we can talk more about in a bit.
What disturbs you about it?
Well, so normally we don't have litmus tests when we choose a nominee. The reason that bothers people is that the idea of a litmus test here, for example, Donald Trump said his were that the nominee would be willing to overturn Roe versus Wade, would vote for religious liberty that would protect evangelical Christians, and third, would vote in a way that would uphold the Second Amendment right to have a gun for individual use. The reason we don't like that, and we prefer more presidents think about judicial philosophy, et cetera, is because it gives this idea that a person is guaranteeing a vote in order to get the nomination. So the fact that this nominee is someone who would be willing to overturn Roe obviously concerns me. But I think one of my reactions more generally was to his professed originalism that Ken was talking about before. And as you said, the idea that he looks at the Constitution as the framers of the Constitution intended it. So my real question is, what parts of the Constitution is he looking at? Because look, I consider myself actually a progressive who cares deeply about the text and history of the Constitution, but it's important to make sure you're looking at the whole Constitution. A lot of conservative originalists, and I would say Justice Scalia is a prime example of one, like to look at the Constitution as it was in 1789, but don't take into account the what I think genius, beautiful, and inspiring changes to the Constitution that have been made by we the people over the time, particularly those changes to the Constitution after the Civil War that wrote into the Constitution equal protection of the laws for all people, that vastly empowered the federal government to enforce guarantees of equality and liberty, that guaranteed the right to vote free from discrimination for women and people of color. Does Neil Gorsuch think that those guarantees are as important as the ones he might like the gun rights?
We're up against a break, but Professor Josh Blackman, I do want to start to get your reaction to Neil Gorsuch. I'll try not to cut you short if we're coming up on a break, but what was your initial reaction when you heard that Gorsuch was the nominee?
So first, I have to take a victory lap. I run Fantasy SCOTUS, which is a prediction market about the Supreme Court, and our market for the past 2 months has been calling Gorsuch since December, long before he ever rose to the top when other judges were at the top. So I will take a little victory lap.
Wait. You play fantasy football with the Supreme Court?
For the last 9 years, I've run Fantasy SCOTUS. It's a Supreme Court prediction market, and we predicted cases. We predicted Elena Kagan in 2010, and we nailed Neil Gorsuch about 2 months ago. Since December, Fantasy SCOTUS from Lex Predict has been predicting that Gorsuch will be at the top of the pack, and we nailed this, so I am going to take a well-deserved victory lap.
Well, before we hit a break, and we're close to a break, what do you think was the strongest predictive factor that Gorsuch would be the pick?
I think it was a combination of several factors. First, he had been confirmed unanimously, which puts a number of Democrat senators in a tough spot. Second, he has a record. This isn't some sort of cipher like a John Roberts who was on the bench for 5 minutes. He's been a judge for nearly a decade, and he's told us what he thinks. And third, he has writings. He's given lectures, speeches, books, and articles, so we can get a deep sense of his philosophies. There were no surprises here. I think this is a very strong pick all around.
We'll continue this conversation on the other side of the break with Kenneth Jost of the Supreme Court Yearbook, Elizabeth Wydra of the Constitutional Accountability Center, Josh Blackman of the South Texas College of the Law, and with you. We'll get in some of your questions and thoughts in just a moment. I'm Joshua Johnson. Glad to be with you. You're listening to 1A from WAMU and NPR. This is 1A. I'm Joshua Johnson. We're discussing some of the key Supreme Court cases that could be affected by the 8-justice bench we have now, or a different balance if Neil Gorsuch is confirmed as the 9th justice to the Supreme Court. We're discussing it for the hour with Elizabeth Wydra of the Constitutional Accountability Center, Kenneth Jost of the blog Jost on Justice and the Supreme Court Yearbook, and South Texas College of the Law professor Josh Blackman of the Cato Institute. We'll get into some of your questions and thoughts in just a moment, so please do keep them coming. Comment on our Facebook page, tweet us at 1A, or email us 1A@WAMU.org. Josh Blackman, I had to cut you short before the break. You were telling us about some of the factors that you thought made him a shoo-in based on your Supreme Court fantasy football website.
Yeah, so the website is Fantasy SCOTUS, that's Supreme Court of the United States from Lex Predict. And we've been taking predictions on this since November. And I think three things about Judge Gorsuch really led him to rise to the top fairly quickly. First, he was unanimously confirmed about a decade ago. So virtually every senator who's still in the Senate voted for the guy. Second, he has a fairly long record of written opinions. We know what he thinks about religious liberty, about administrative law, and other topics. This isn't a Souter. This isn't a Roberts where they were judges for 5 minutes, then got appointed. And even more than that, he's actually given lectures and speeches and wrote books. So we know what he thinks outside of the judicial role. When you're on the Supreme Court, you're not bound by precedent the same way you are on a lower court. So these give us insights into how he would rule as one of the 9. So all around, I think this is a fairly wise choice, and it makes people in Federalist Society circles fairly relieved. Talk about his writing a little bit more. Kenneth Jost had mentioned at the top of the program that he's considered an excellent writer. What exactly do we mean by that? Does that mean how he expresses his views in words, or the way he explains his legal precedent, or just his skill with vocabulary? Like, what exactly does that mean from a legal perspective?
His writings are described as emphasizing readability and accessibility. And indeed, within the past couple of days, a couple of those opinions have been cited that begin in ways that actually parallel the way that Chief Justice Roberts and Justice Elena Kagan have tried to write more engagingly than than the more legalistic writing of some of their colleagues.
Not super complicated or wonky, but so that anybody could pick it up and make sense of it.
Exactly right.
Speaking of cases that get cited, we're already getting some questions about some of Judge Gorsuch's previous cases, including the Hobby Lobby decision. Jess on Facebook wrote, "The Hobby Lobby decision seems to be the case most supporters land on when outlining their defense of him. How does this decision compare with the rest of his record?" Ken Jost, before we talk about his perspective on it, remind us, what was the Hobby Lobby case?
So the Hobby Lobby case is the decision, 5-4 decision by the Supreme Court, reversing a decision by Judge Gorsuch's court that allows a private, religiously motivated employer to get an exemption from the requirement under Obamacare to provide coverage, cost-free coverage of contraceptives in any employee health benefit plan. Fiercely argued on one side by conservatives, including Josh Blackman in his book, and on the other side by women's groups and abortion rights groups.
So Judge Gorsuch, as part of the 10th Circuit Court of Appeals, of which he was part, wrote a dissent to that court's decision.
That's right. So on religious liberty issues, check for religious conservatives.
Elizabeth?
Yeah, I just wanted to say that I think there's another wrinkle to that case that is important for a lot of us beyond just the troubling, to me, issues on access to contraception. And that's the corporate angle here. Corporate personhood is obviously an issue that is important in the campaign finance context and other First Amendment areas. But here, this was really the first time that corporations were given what had previously been individual rights of conscience under religious liberty protection doctrines. And so, for example, Constitutional Accountability Center, my group, filed a brief that was a progressive originalist brief right in Judge Gorsuch's wheelhouse that talked about the way that the framers of the First Amendment, of the religious liberty clauses in particular, saw them as individual rights of conscience and belief, something that corporations as artificial entities of the state simply don't hold. So for those of us who have deep concerns about Judge Gorsuch's record, his dissent in that case raises concerns on religious liberty grounds, giving an over protection to religious liberty grounds, even when they extinguish the rights of women to contraception under a law that they are clearly entitled to contraception under. We're concerned about the reproductive choice issues and access. And thirdly, we're concerned about an overbroad vision of corporate rights. You know, a lot of Trump voters purportedly voted for him based on economic issues. And if you put someone on the court that adds to the very pro-business bent of the Roberts Court, our studies have shown that the Roberts Court is the most pro-corporate of the modern era, then they could have a rude awakening when they have someone there who's going to only entrench a court's bent toward bending over backwards to accommodate special big business interests at the expense of average Americans.
Professor Blackman, what's your read on the way that Judge Gorsuch views cases involving business?
So there's actually a different wrinkle if we can pivot to a new point. There's a doctrine in law known as the Chevron doctrine. And this roughly means that when Congress enacts a statute telling an agency, go do X, and they tell them to do something that's simply ambiguous, right? They say, go regulate air quality at a reasonable level. They don't say what that level is. The Chevron doctrine notes that courts will simply defer to the expertise of the agency. So they decide 5 parts per million of a pollutant is a reasonable level. Courts will defer there. In one of his more notable decisions, Judge Gorsuch has called to reconsider the Chevron doctrine and say that courts are effectively abdicating their role of judicial review. And this follows a trend set by Justice Thomas, who's also said the Chevron doctrine is basically unconstitutional. So now we have at least 1, possibly 2 votes in the Supreme Court to revisit the Chevron doctrine. This is something far more than the corporate personhood issue that corporations will be very interested in, because this will perhaps scale back regulations. But I'll caveat this. Skepticism of the Obama administration is one thing. Now we may have skepticism of the Trump administration. And it's very possible that Trump supporters will not like this, and he may rule in ways that the president won't be happy with. Fortunately for life tenure, once he's confirmed, there's very little that Trump can do about it. But this is another wrinkle for your listeners to consider.
We've been getting a number of questions on Twitter and by email about this term originalism. And it's come up a couple times in the hour so far, but I think it's it's kind of a wonky term if you don't really follow the court and in terms of the way that it actually plays out in practice. Professor Blackman, how do you see this idea of originalism playing out in practice? Help us explain this to people who are kind of new to this concept.
Sure. So originalism is the idea that we should interpret a text based on how its framers would have understood it. And this is a fairly common sense idea. If you and I make a contract and we agree to things, and then 5 years later there's a term in the contract that we're not sure about, maybe we'll check a dictionary of what did that term mean, how would we have understood it. The difficulty of originalism is what happens when it conflicts with precedent. So say the Supreme Court has been for 70 or 80 years ruling that the free speech clause means one thing, and then we have some evidence meaning that perhaps in 1791 it meant something different. How do you interact precedent and originalism? Justice Thomas is the purest originalist. He said that he's willing to revisit any case, no matter how old it is, if he finds it conflicts with the original meaning of the Constitution. So the New Deal precedents, which are very significant, Thomas would chuck. Justice Scalia called himself a faint-hearted originalist. He said he will, if it's a new provision that hasn't really been interpreted, he will go to originalism. But for certain older precedents, not all, but certain older precedents, he'd be willing to simply follow them because they're water under the bridge. Now, the big question for Judge Gorsuch is, how do you decide when to follow precedent, and how do you decide when to follow originalism? And this is something that I hope this confirmation hearing will elucidate.
Yeah, I wonder how that applies to certain social issues. I mean, we now have an amendment to the U.S. Constitution that guarantees me full personhood and the right to vote because I'm black. But I don't think that's what the founders intended or foresaw. So how does an originalist navigate that?
Well, that's actually not a difficult point. Elizabeth made this well. Our Constitution has been amended, thank God. It's been amended several times, and we do not only have the Constitution of 1791 and 1789, we have the Constitution of 1868, which is when the 14th Amendment was ratified, which gave full personhood to all citizens born in the United States. And I think that was a very good change.
So it's not always just the founders, but the writers of that amendment, because the founders didn't pass the 13th, 14th, and 15th Amendments.
Indeed, Elizabeth's group, the Constitutional Accountability Center, has made a very good PR push to say that there actually were two foundings. There was a founding at the time, 1789, and there was basically a second founding with the 13th and 14th and 15th Amendments. And these are the core aspects of our Constitution that even originalists will respect.
Let's get to another clip from last night's announcement. This is Judge Neil Gorsuch getting a little bit of a laugh line when he talked about the way that he views America's legal system.
I respect, too, the fact that in our legal order, it is for Congress and not the courts to write new laws. It is the role of judges to apply, not alter, the work of the people's representatives. A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands.
Now, we've already kind of talked about this in terms of Judge Gorsuch's interpretation of the law, but Josh Blackman, I wonder if you could speak more to his personality. I was not expecting the nominee to say anything at all funny, but by many accounts, he's a very collegial, very decent guy to deal with, right?
He's a very nice guy. And just a small anecdote, I mailed copies of my book Unraveled to a lot of judges, especially judges who ruled on the Obamacare cases. Virtually none of them even acknowledged it. Judge Gorsuch almost immediately sent me, a personalized note, personally signed, like within a couple days. From what I hear from his clerks, he's very friendly. He knows everyone in the courthouse, knows every member of the staff, the security detail, the sanitation staff. He always knows people are having illness in the family. He's really good. In fact, I was talking to a reporter from a major newspaper, and they're saying, "Do you have any dirt on this guy?" I'm like, "I got nothing." And I think Ken was mentioning Judge Garland before. I think they're cut from the same cloth. These are very good judges. They're very kind people. They have good reputations. They're not abrasive. Scalia could be a little bit abrasive, right? This guy doesn't have that, and I think he came off smoothly. In fact, the David Latt has taken to calling him the silver fox because of his hair, but I think he's very smooth. He comes across very well, and I think his meetings with the senators will go quite well.
Let's get down to some of the more controversial issues that the court might deal with. A number of people listening have asked us about some of these very complex, difficult social issues that, as Elizabeth put it, might come up as a litmus test for whether or not a nominee would be confirmed. Cameron tweeted us, how can the Supreme Court of the United States revisit and overturn a precedent such as Roe v. Wade? Ken, without trying to speculate on whether the court will, Talk about just how that would have to happen. If there's someone who wants a justice who would overturn Roe v. Wade, what would it legally take to do that?
So let's start from square one. Roe v. Wade was a compromise decision that held that women have a qualified right to choose whether to terminate a pregnancy, and at designated stages of a pregnancy, a legislative body, state legislature or Congress, can pass a law regulating or limiting the procedure. And so a legislature in whatever red state you want to choose could pass a law going a little farther in limiting choice, and that law would of course generate a challenge, and that challenge would reach the Supreme Court. And the best example is the laws prohibiting so-called partial birth abortion, which were struck down 5-4 before Roberts and Alito, and then upheld 5-4 with Roberts and Alito on the bench.
So it would take basically something to provoke another legal challenge. A law would have to be passed, and then someone would challenge it, and then it could work its way through the process.
And then one side might say, and in addition, why don't you consider overturning Roe v. Wade? And would this court flatly overturn Roe v. Wade? My guess, no, but they can snip it at the edges.
Elizabeth?
Yeah, and those laws are being passed all the time that try to chip away at Roe. We just saw a decision last term about these laws that try to make an end run around the constitutional right to choose an abortion. Out of Texas and other states, there were laws that would basically close most of the clinics in those states, and therefore you'd have the right, but really no way to exercise it. And so we saw a strong opinion from the court last term reaffirming basically that you can't burden the right to an abortion and still pass constitutional muster. So it's very concerning that Donald Trump is intent, as he stated during his campaign, in putting someone on the bench who would be committed to overturning Roe versus Wade. And I think it's not just Roe, it's all these other issues that probably many of your listeners are concerned about: marriage equality, voting rights, civil rights.
We did get a question on Twitter, probably several, about marriage equality.
Yeah, and he hasn't ruled on that specifically during his time on the 10th Circuit, but he did write a column which I find concerning that criticized what he called liberal lawyers using the courts for what he called social issues. I don't really think of them as social issues. I think of them as constitutional guarantees, which I'm very glad that we over time have written into our Constitution. So to me, it's troubling that he views people coming into court and demanding that the court vindicate their constitutional rights, which is their right, and it's the court's duty to adjudicate those constitutional claims, that he views those sort of as, kind of intrusive follies put on by liberal lawyers.
Professor Blackman, I wonder if it kind of muddies the waters to have these kinds of social issues be hanging over the entire confirmation process. I mean, if I look back at what Judge Gorsuch said last night, he said, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands." It would seem that that's focusing more on the way he makes legal decisions rather than, well, what do you think about gay marriage? Well, what do you think about abortion? Well, what do you think about a physician-assisted suicide? What do you think about this political issue? Doesn't it make it harder to confirm anyone if it's more a matter of politics than jurisprudence?
Well, I think Judge Gorsuch's line was exactly right. The bit about if you're a bad judge, if you're thinking simply about how the outcome of a case will turn. Justice Scalia famously told a story that you're a good judge when you rule in a way you disagree with. This is a great story. So in the late 80s, there's a case called Texas versus Johnson that considered flag burning, and whether a person could be convicted for a crime for burning a flag at the Republican National Convention. Now, as a matter of policy, Justice Scalia said he would lock up every hippie flag burner and throw away the key, right? But he actually ruled and cast the fifth vote to invalidate the conviction. And there's this great story. So apparently the next morning, Scalia was at breakfast with his wife, Maureen, and his wife was looking at the front page of the Washington Post that Scalia voted to rule for the flag burner. And apparently she started humming the national anthem, and then Scalia said, "Forget this, I'm going to work." But I think it's a good thing. Also, about a week ago, Justice Sotomayor was at a speech in Arizona State, and she said, I'll read the quote for you. She said, "Any self-respecting judge who comes in with an agenda that will permit that judge to tell you how they will vote is the kind of person you don't want to be as a judge."
Let's continue that conversation. Let's continue that on the other side of the break. We're coming up on a break. I know I keep interrupting you. I'm really sorry, but we'll continue with that point on the other side as we continue discussing the Supreme Court and its future. Stay close. Before we get back to our conversation, we would love to hear from you for tomorrow's program about the federal workforce. President Donald Trump has come under some fire for how he has treated some government workers. He told diplomats overseas to be gone before he took the oath. He fired the acting attorney general for refusing to defend his immigration ban. If you are or were a federal employee, what has your experience been with new administrations? Maybe the Trump transition has affected you directly, or maybe you've dealt with this kind of thing before. Leave us a voicemail, 855-236-1A1A. If you are or were a federal employee, what has your experience been with new administrations? Tell us your story, and we know this is a sensitive topic, so if you need to remain somewhat anonymous, we understand. 855-236-1A1A. That's 855-236-1212. You can also make a voice memo with your smartphone and email it to 1A@WAMU.org. We'll play some of your stories tomorrow on 1A. Let's get back to our conversation about the Supreme Court with Elizabeth Wydra of the Constitutional Accountability Center, Kenneth Jost of the Supreme Court Yearbook, and Professor Josh Blackman of the South Texas College of the Law. Professor Blackman, you were making a point about Sonia Sotomayor before we went to break.
I feel like on the Academy Awards, they start playing the music and I have to shut up. The point, Justice Sotomayor made a very good point a week or two ago. She was speaking at Arizona State, and she said, quote, any self-respecting judge who comes in with an agenda that will permit that judge to tell you how they will vote is the kind of person you don't want as a judge. She added, what you would want is for a judicial nominee to say, we're going to rule in a way consistent with the text of the Constitution, not like, specific issue. Here's what I'm going to do. And I think that's a guiding lesson for the confirmation hearing coming up. We don't want to ask them, so what are you going to do on abortion? What are you going to do on same-sex marriage? What are you going to do on guns? That's not a very useful question. You don't want them to tip their hand. That's why Elizabeth is correct. Litmus tests are awful ideas. You don't want that. Instead, the question to try and dive deep into a judge's philosophy, how they view the law, and especially for the Supreme Court, how they will rule in the absence of any governing precedent, which is often what happens for them.
Kenneth Jost, I think there were a few more cases that you said we should bear in mind, business-related cases that should be part of this conversation.
Yes, but first let's mention one that Josh kind of halfway touched on, and that's the transgender student case, the case from Virginia where a transgender boy wants to use the boys' restroom instead of the restroom based on his birth.
This is Gloucester County School Board versus
Gloucester County
GG.
versus GG. And that's a case, if Judge Gorsuch joins the court by April, he could be the pivotal vote on a case like that between the two the conservative bloc and the liberal bloc. There are also two important business cases, one of which involves whether an employer can require an employee to give up his right to go into court in case of a dispute. That's a case being very closely watched by business groups and on the other side by workers and consumer groups. And a second case involves how easy it is to sue a corporation in a state where it's not headquartered. Business groups have filed a bunch of friend of the court briefs in that one. So that one's very important to business groups.
Elizabeth Wydra, your organization, the Constitutional Accountability Center, has filed a friend of the court brief, an amicus brief, on behalf of GG. Talk about what's at stake in this case as you see it.
Yeah, absolutely. So it implicates, obviously, the important guarantee of equal protection for all people. And, it says the Constitution, when it's talking about equal protection, uses the word persons. Persons is obviously the broadest word that the framers could have chosen. And they, if you look at the debate, specifically chose a term that would be universal. Transgender people obviously are persons under the Constitution. And then we have laws that Congress passes to enforce those constitutional guarantees. Here we're talking about Title IX, which talks about not discriminating on the basis of gender in schools. So that's what we're talking about here. It also has an important wrinkle because the Obama administration issued an interpretation of Title IX saying that it applied to transgender students and protected them, particularly in these types of cases. The Trump administration might change that. And so the question is what the Supreme Court will do, whether they will go ahead with there is the possibility that they could just rule on the Title IX issue itself and not take into account any administration guidance on what that administration thinks. But I think it also raises the broader point that goes to the background of this nomination hearing and any of these cases that come up before the court, and frankly to the role of a judge or justice, him or herself. And that's the requirement that you are faithful to the law and the Constitution itself, that you are independent from the political party and the president who is responsible for putting you on that bench. And I think a lot of us have seen in the past few days the importance of the courts as a check on constitutional violations and overstepping of power from the elected branches in these Muslim ban cases. And so it's so important that Judge Gorsuch show in his hearing that he will be that type of independent judge, that he will not, as we've been talking about, come on the bench with a political agenda or some sort of loyalty to President Trump, whether it's through these litmus tests or whatever, but that he will be faithful to the Constitution, the whole Constitution, and the law itself.
Let's get to a few more questions and emails from our audience. You do have a little bit more time to get your questions in about the Supreme Court and its future. 1a@wamu.org. Tweet us at 1a or comment on our Facebook page. Margaret emailed us, "My first impression as I watched the announcement of Gorsuch's nomination was that the room was filled primarily with white males. There was no diversity apparent. When the Constitution was written, it was written with one class of people in mind, primarily white males. This country's demographics have changed dramatically since then." Josh Blackman, do we need another white guy on the Supreme Court?
Oh, what a loaded question.
But it's an honest one. I mean, isn't there room for more diversity on the Supreme Court?
Oh, I think there's room for geographic diversity as well. In fact, Judge Gorsuch is the first person not from a coast to be nominated since John Roberts.
And he's a white guy. I mean, there have got to be conservative jurors who are women, who are people of color. They may not lean as far to the right as Judge Gorsuch does. And, you know, depending on how far afield you have to cast a net, you might have to cast a wide net. But is it real? Aren't there anybody we could pick other than another white guy?
So if you want to go back to some history, there were a couple prominent minority judges on the Bush administration who appointed that did not go well. Miguel Estrada, for example, was a lawyer who was appointed to the D.C. Circuit. He was a Honduran immigrant with a wonderful story. The Democrats realized he might be a future Supreme Court nominee, so they filibustered him. They put him through hell. Janice Rogers Brown, another African-American female, had a great record. California Supreme Court Justice, she was put through hell. So I think that the pipeline perhaps dried up a bit because Democrats recognize that these might be viable candidates. But with all respect, Judge Gorsuch is very well qualified. He comes from the middle of America, has great values. I think will bring a lot of new insights to the court.
Well, then let me flip it around a little bit to either you, Elizabeth, or you, Kenneth. What difference does it make? If the primary responsibility is to have someone who interprets the law as the law is intended and not to bring their own political litmus tests into it, why does the complexion of the court even matter?
I think, obviously, anyone, no matter what they look like, what nation they're from, in their ancestry, should be focused on the Constitution and the law. But I think that, as we've seen with some of the recent opinions, it does make a difference if you have a broad view of the reality in which law plays out on the ground. We've seen some very powerful opinions from Justice Sotomayor on the way that policing, and particularly intrusive policing, violent policing, affects communities of color. And I think that was very powerful, not just in informing the way that the law and the opinions were written from the Supreme Court, but in the way that people hear the Supreme Court speaking to them. The way that she writes, I think the affirmative action case is another example, role is something that people can see themselves in. They can see their experience reflected in. And that's incredibly important when you have the Supreme Court issuing opinions that govern the most intimate aspects of our lives. And I disagree that there aren't any conservatives out there who are people of color or women on the bench because of, yes, there were a couple nominations. There was one, Miguel Estrada didn't work. Judge Brown is on the bench. So he could have picked someone who was not another white guy.
Ken Jost?
Gorsuch also scores 0 on 2 other aspects of diversity, socioeconomic. So he comes from a, upper middle class family. The candidate who apparently came in second, Thomas Hardiman, federal appeals court judge in Pittsburgh, blue collar background, worked his way through law school by driving a cab. And Judge Hardiman had a record of representing the immigrant community here in Washington, D.C. with a legal aid outfit called Ayuda, which in Spanish means help. There's nobody on the court right now other than Sotomayor with a solid record, and Justice Ginsburg, I guess, with a solid record of pro bono work as a lawyer. Justice Ginsburg, Women's Rights Project with the ACLU before going on the bench, and Justice Sotomayor with the Puerto Rican Legal Defense Fund in New York.
Let's talk about how the confirmation process might go. Here is a clip of Arizona Republican Senator John McCain from October of last year. He was speaking to a radio program in Philadelphia about the possibility of a different nominee winning the presidency.
I promise you that we will be united against any Supreme Court nominee that Hillary Clinton, if she were president, would put up.
That's Arizona Republican Senator John McCain speaking on the Dom Giordano program on WPHT. So he said that if Hillary Clinton had won, any nominee she would put up, it would be a solid stone wall. Elizabeth Wydra, are we expecting the same from Democrats this time around?
I think it would, the treatment of Merrick Garland, who is President Obama's nominee, the unquestionably qualified Chief Judge Merrick Garland from the D.C. Circuit, that is fresh in everyone's mind. I think that was unconscionable, the way that Senate Republicans blocked his nomination. Going into this one, obviously, there are people who view this as a stolen seat, that any nominee from President Trump is going to be illegitimate. But I think there is going to be a fight. The question is it a fight where we look very closely at his record, subject him to incredibly tough and fair questioning at a hearing, and then perhaps a lot of Democrats vote against him? Is there going to be a filibuster? I think a lot of it depends on, frankly, the review of his record, how he responds, and that's important. That's why we have these processes, and it's a shame that Merrick Garland was denied even a hearing, much less a vote.
Professor Blackman, what do you think?
Everyone's a hypocrite in this issue. Where you sit depends where you stand. I think had Hillary Clinton won and the Republicans at the Senate, the dynamics would be, let's keep the seat open. If the Republicans are here now, they're going to support it. The big issue, which I think your listeners should worry about, is not the issue on the Republican Senate and Republican president, is what happens if in 2 years there's a Republican president and a Democratic Senate and they decide to confirm no one. And you could actually have a empty seat, what I call the Clint Eastwood effect. You can have an empty seat for years on end until you have a situation where the president and the Senate are the same party. That's the big problem you have to look out for.
But I also keep hearing about this so-called nuclear option. Ken Jost, can you just explain in plain English what that option would involve? Is this like the ultimate showdown if they can't come to consensus on this, or what is this option?
So in the Senate, it takes 60 votes to say, okay, we're through debating, let's vote.
That's called cloture.
That's called cloture. The nuclear option, which the Democrats put into effect when they were trying to get lower court judges confirmed, especially in particular the federal appeals court here in the District of Columbia, which was closely balanced, and they adopted a rule that said, okay, we only need 50 votes to proceed to a vote on a lower court nomination, but they kept the 60 vote requirement for the Supreme Court. And so one question to Senator McConnell is, well, will you adopt the nuclear option, the only 50 votes needed for the Supreme Court? And to that, Senator McConnell has simply said, President Trump's nominee will be confirmed. period.
So he won't even really answer that.
He won't answer that question.
Let's throw in one more question. Langham tweeted us, I wonder how your guests think Judge Gorsuch is likely to rule on organized labor cases. Elizabeth?
Yeah, I think that that's obviously a real big concern. We've seen labor groups come out very strongly, either against or expressing very strong concern against the nominee. He has generally been very pro-business. He has ruled in cases against a claim of workers who were trying to seek back pay. There are also cases where he ruled against whistleblowers. So I think there's a lot of concern there. And this is frankly one of those issues that will be coming up to the Supreme Court very soon. One of the cases that basically didn't get decided because we had an 8-justice court was a case about labor unions and the ability of labor unions to take what we call fair share fees. That's that part of union dues that goes to organizing for common goods like better workplaces, better pay, better benefits, et cetera. The court split on that, and so we need a 9th vote, and Scalia probably would have voted against labor unions in that case. I think a lot of people are expecting it to shoot back up to the Supreme Court, and business certainly hopes that Gorsuch will be the 5th vote to rule against labor unions, and labor unions obviously are very concerned about that.
Briefly, Josh Blackman, before we have to start playing the Academy Awards music and escort you off the stage again, what do you think it's going to take to get Neil Gorsuch confirmed in this political climate in which many Democrats are still angry about how Merrick Garland was treated? Briefly.
It will depend on how bad they think the next one is. If the Democrats overplay their hand and filibuster now, it may result in the Republicans saying, okay, we'll nuke it. And then when Justice Kennedy retires in 2 years, you can appoint someone far more conservative. If they're conciliatory now, there's an outside chance that there may be some compromise and wiggle room for the Kennedy nomination in a couple years. But if they push too hard now, it may backfire.
That's Josh Blackman. He's an associate professor at the South Texas College of the Law, an adjunct scholar at the Cato Institute, and the author of Unraveled, Obamacare, Religious Liberty, and Executive Power. Professor Blackman, thanks for spending the hour with us.
Thank you.
Kenneth Jost is the author of the Supreme Court Yearbook and the writer of the blog Jost on Justice. Kenneth, thank you.
Glad to be here.
And Elizabeth Wydra is the president of the Constitutional Accountability Center. Thank you, Elizabeth.
Thank you so much.
Remember to share your stories with us about being a federal government worker during a time of transition, especially if you work with the Trump administration now. 855-236-1A1A or email 1A@WAMU.org. 1A comes to you from WAMU, part of American University in Washington, distributed by NPR. I'm Joshua Johnson. Thanks for listening. This is 1A.